certificate.
Sir Graham, I rise to speak in favour of the amendments 43 and 44 tabled in my name, and also to give my support to the amendments tabled in the name of the Scottish National Party and our friends from the SDLP and our friend from the Alliance Party. Sir Graham, I'm going to focus my comments mainly on my amendments, which are laid to try and work out just how far this government are prepared to go in ousting the jurisdiction of the domestic courts in relation to judicial review and review under the Human Rights Act in clause 45 as it appears on the face of the bill. And I also wish to highlight, as I mentioned in an intervention on the Minister earlier, that insofar as clause 45 seeks to restrict judicial review in Scotland by circumscribing the supervisory jurisdiction of the Court of Session, not only does this trespass into devolved territory, but it may very well also breach another treaty, the Treaty of Union between Scotland and England, Article 19 of which preserves the independence of the Scottish legal system. But, Sir Graham, for the avoidance of doubt, before I address my amendments in detail, my primary position is, and I find myself curiously here on the same ground as the Right Honourable Member for Maidenhead, my primary position is that clauses 41 to 45 should not stand part of this bill. And for everything we heard from the previous speaker, I think was designed to hide from us the fact that what we are talking about here is a bilateral treaty that was entered into by the Prime Minister and by the United Kingdom less than a year ago to deal with a specific situation that arose between the United Kingdom and the European Union, and the part which was the most controversial was the part dealing with Northern Ireland, the north of Ireland. And this is the part which this government are seeking to drive a coach and horses through. That's what we're talking about, and that is what is so wrong. And, well, I'm going to make some progress. Such excuses as those of the government's law officers who remain in post have sought to make for this do not stand up. And I have to say that I'm very proud as a member of the Scottish Bar that Lord Keane of Ely resigned last week, and I'm proud of the reasons he gave for his resignation. The only thing I would say to him is, what took you so long, Richard? But apart from that, I'm very proud, and I think it will be very difficult for the British government to find anybody of suitable seniority from the Scottish Bar to step into his shoes. But I'm waiting with some amusement to see who they might find. Anyway, talking of rather less senior lawyers than Lord Keane of Ely, the English Attorney General has said that the English doctrine of parliamentary sovereignty means that it's lawful for the United Kingdom to override these obligations signed up to in the withdrawal agreement. I think that's what the previous speaker, the Right Honourable Gentleman, was saying when he referred to Section 28 of the EU Withdrawal Act. This idea that the English doctrine of parliamentary sovereignty somehow trumps international law. It's legally illiterate. Indeed. It's what we would call at the Scottish Bar. No, I'm going to make some progress. It's what we would call at the Scottish Bar a load of old mints. And that's not just the view, that's not just my view, it's not my view. It's, as I said earlier in an intervention, the view of the United Kingdom Supreme Court, who said in the first Miller case, at paragraph 55, treaties between sovereign states have effect in international law and are not governed by the domestic law of any state. So I'm terribly sorry to disappoint the members opposite. No matter how much you love your doctrine of parliamentary sovereignty, no matter how much it means to you, it cannot trump the obligations, no, I'm not going to give way, the obligations freely entered into by your government under international law. It just simply doesn't work that way. Britannia doesn't rule the waves any longer and hasn't done so for some time. Now, I regret to say that whilst I have, and I really mean this, the greatest respect for the honourable and learned member for Bromley and Chislehurst, and the highest regard for him, the government amendment which his efforts have secured is wholly inadequate to meet both domestic and international concerns about this bill. And I cannot really do much better than quote what the Irish Foreign Minister has said this afternoon. He said a government with an 80-seat majority having a parliamentary lock is not much of a reassurance to any of us. And I really don't think I need to say it any more than that. It's once more, it's a ruse to solve the problems of the party opposite, rather than a ruse to address our international legal obligations. But turning to my amendments 43 and 44, as I said, they seek to deal with clause 45. And I'd like to quote what the Bar Council, the English Bar Council and the Law Society of England and Wales have said about clause 45. They've said, as it appears on the face of the bill, it would exclude judicial review of any regulations made under clause 42 or 43 on the grounds of incompatibility with domestic law as well as international law. And that exclusion of judicial review would mean also excluding any human rights review under the Human Rights Act or indeed the Equality Act. And as my honourable friend, the member for Belfast South, said in her very eloquent speech earlier, human rights are of course integral to the Good Friday Agreement. And it's a travesty that regulations made under 42 and 43 should not be subject to judicial review or to human rights review across Great Britain, but a particular travesty in Northern Ireland. It undermines not just the principle of the rule of law, but the principle of access to justice. And it also contravenes Article 4 of the Withdrawal Agreement, which the British government freely signed up to, in which the British government undertook to ensure a right for individuals to directly rely upon withdrawal agreement provisions. Now, it is difficult to be certain, Sir Graham, how the courts would attempt what is on the face of the bill in clause 45, how the courts would interpret an ouster clause like this, but precedent suggests it would be quite hard for the courts to hold it up unless it's expressed in unequivocal terms. But my amendments seek to clear this up by stating in 43 that the Human Rights Act and the European Convention on Human Rights are excluded from the definition of domestic and international law, and by saying in Amendment 44 that nothing in clause 45 ousts the jurisdiction of the domestic courts in respect of judicial review of regulations made under clauses 42 and 43. Now, subsequent to my tabling those amendments, the government tabled their amendments 64 and 65, and these appear to me to be an acknowledgement that judicial review claims could still be brought in certain limited circumstances. Now, I'd be interested to hear from the Minister what those circumstances would be. Do they include just the normal judicial review grounds of illegality, irrationality or procedural impropriety? Or will he also include review on the grounds of human rights? So I'll look forward to hearing from on that. But my final point is this, Sir Graham, and it's, from a Scottish point of view, it's the most important point. Insofar as clause 45 seeks to interfere with judicial review in Scotland, it is interfering with rather a different beast from judicial review in England. It's interfering with the inherent supervisory jurisdiction of the Court of Session in Edinburgh. And in doing that, it's straying into devolved territory and therefore would require a legislative consent motion, which I very much doubt would be forthcoming. Put quite simply, Sir Graham, the Scottish Parliament is not in the business of ousting the court's jurisdiction on judicial review or human rights grounds, nor should it be, and nor should this Parliament. But perhaps most importantly, from a Scottish point of view, Sir Graham, the supervisory jurisdiction of the Court of Session is an inherent jurisdiction. It's not something that's conferred on it by legislation. It has been there since the inception of the court in 1532. Therefore, it predates the Treaty of Union between Scotland and England in 1707, and legislation seeking to narrow the scope of that inherent jurisdiction risks falling foul of Article 19 of the Treaty of Union, which preserves the independence of Scotland's legal system. Now, in Scotland, we learned rather to our surprise from the UK Supreme Court that putting the Sewell Convention on a legal footing had no impact in protecting us from the government driving a coach and horses through it. So this government, it seems, can, as the legal position stands in the United Kingdom at the moment, get away with passing primary legislation which interferes in devolved matters without a legislative consent motion. But breach of Article 19 of the Treaty of Union might be a different matter, because the question of whether certain parts of the Treaty of Union are so fundamental that they can't be overridden by an act of this Parliament has been considered by the courts north and south of the border, but it's never been entirely resolved. And I would simply remind members of this House that the doctrine of supremacy of Parliament is an English doctrine.
Indeed.
And even Dicey, the great high priest of parliamentary sovereignty, was prepared to recognise that those who framed the Treaty of Union between Scotland and England believed in the possibility of creating an absolute sovereign legislature which was still bound by certain unalterable laws. And many of us in Scotland believe that one of the unalterable laws of the Treaty of Union is that this Parliament cannot interfere with the inherent jurisdiction of the Court of Session. And both of these problems, the inroads into the devolved competence, the undermining of Article 19 of the Treaty of Union, will continue notwithstanding government amendments 64 and 65. Now, I suspect the government haven't really thought about this because, let's be honest, they don't think very often about the impact of what they want to do in Scotland. But many people in Scotland, including members of my profession, the legal profession in Scotland, will see this as just another example of this government's total disregard for devolution and total disregard for Scotland's separate and distinct institutions. And Sir Graham, that's yet another reason why the only way out of the mess that the Conservative and Unionist Party have created over Europe, the only way out for Scotland is independence. And I'm just glad that so many more people in Scotland are realising this on a daily basis. And I know it's a terrible, dreadful bore for the members opposite, but I would just remind them, we have to spend an awful lot of time listening to them bang on about the European Union and how the European Union, how the European Union, how the European Union prevents them from having their way. Well, the Scots are pretty sick, Sir Graham, of this Parliament preventing Scotland from having its way, and I will give way to my honourable friend.
I'm very grateful to my learned and honourable friend for giving way. In a historical perspective, maybe my honourable learned friend would agree that we need to go back to maybe the 15th and 16th century, that this is a modern-day English Reformation that seeks to impose on Scotland a modern-day Brexit prayer book. The Kirk rejected it then, and Scotland will reject them now.
Well, it's correct, and it's funny to hear my honourable friend talk about the Kirk, as he and I were both brought up in the opposite persuasion. But of course the Church of Scotland is also protected by the Treaty of Union. So mock away, if you will, and I don't mean you, Sir Graham, mock away on the benches opposite. Feel free to continue your mocking. Yes. Your mocking is viewed in Scotland, and it simply feeds the desire for Scotland to go a different way. So keep up the mocking. It's helping my party's cause, and it's helping the cause of my country. Thank you, Sir Graham.
Thank you very much.